Carpe Diem. So today we have our alumni, Mr. Alok Prasanna Kumar, who graduated from Nalsar about 10 years ago. And he went on to pursue his master's from Oxford after that. He's one of the co-founders of Vidhi Centre for Legal Policy, and he currently heads the Bangalore office of the centre. In today's talk, he'll be shedding important light on issues of credibility and capacity of the Indian judiciary. The format which we'll follow is that he'll be speaking for about 40, 45, 50 minutes. After that, Mr. Siddharth Chauhan will be the discussant for the talk. So he'll be opinionating his opinions about the talk. Post that, we'll open the floor for questions. Yeah. So without any delay, we'll start the talk now.
Thank you, Lavish, for that generous introduction. Good evening, everyone, and thank you for inviting me to speak at this platform. It's a privilege to be back at Nalsar to speak on this important topic. So, as you can see, the topic for today's talk is the capacity, constitutionality and credibility crisis of the judiciary, or as I prefer to call it, 10 charts on India's judiciary that will blow your mind. I've chosen these three themes not because I'm a fan of alliteration or anything, but I believe we are living through one of the worst crises of the Indian judiciary. It's not a crisis that began on the 12th of January. It did not also begin when the Chief Justice decided that nobody is allowed to investigate him in November 2017. But it is my contention that the seeds of the present crisis, which really boiled over when 4 judges came out and held a press conference to say that we believe the Supreme Court is not functioning as it should. I think that was in the making for about 2 decades. And it's the outcome of 2 decades of failure on the part of the judiciary as an institution. So in the course of today's talk, for about 45 minutes, what I intend to do is make good on 3 broad claims. The first is that the judiciary as it is structured, as it is presently functioning, is institutionally incapable of meeting its capacity needs. Right? This is in the context of appointments, whether at the higher judiciary or at the lower judiciary. My first point that I'll sort of discuss is how it's an institutional problem. Even though we might see it at present as a government issue, it's actually an institutional problem. The second claim that I make is that the Supreme Court is no longer performing its constitutional role. Now, the reason why I'm focusing on the Supreme Court is because sitting at the top of our apex, of our unified judiciary, how it performs its constitutional role has a big say in how the rest of the judiciary functions and how the rest of the government also functions. So when the Supreme Court fails or does not even perform its constitutional role at all, there are serious implications for our judiciary and for our government. The third claim that I'll make, and I'll try to establish this, is that litigants are losing faith in the judiciary. That we are in a situation where the judiciary's credibility is seriously under question and people have started voting with their feet. They're walking out of the judiciary. So what this means, why I'm saying this, is something that I'll try and explain over the next 40, 45 minutes or so. And I'll try not to ramble on too much because if you give me an opportunity, I'll talk about these things for a whole day. But without any further delay, let me just move on to the first issue that I sort of addressed, and which is the question of capacity. Now, if you go to the Supreme Court website, there's this publication called Court News. It comes out, it is supposed to come out once in a quarter. It is usually delayed by about 1.5 years. The latest version of it relates to data from 2017, January to March. And just from this data, there are some fairly shocking numbers. 445 out of 1,079 posts of High Court judges are vacant. That's about 41%. 5,059 out of 21,944 posts of District Court judges are vacant, and that's about 23.21%. There are certain High Courts, such as the Karnataka High Court, the Hyderabad High Court right here, and the Calcutta High Court, which are functioning at barely half or less than half capacity. Right? Now, the initial reaction to this should be, and if you're following news over the last 1 year, you'd say it's actually the government which is stalling all of this. There's a problem in the way in which this government is approaching the judiciary, and you're partly right. That is the proximate cause for this situation. But if you ask me, there's a long-term reason for this, and that's what the first slide is sort of illustrating. Now this relates to this slide. I'll try to describe it as best as possible. There are actually 3 charts on this. The first top chart, you will see 3 lines running across, and that is the lines relating to percentage of vacancies in the high courts, in the district courts, and the Supreme Court. Ignore the Supreme Court for the moment. It's one court. It's fairly easy to fill up appointments in one big round of appointments. The real trouble is, and you can see from the chart, high courts and district courts have had persistently high level of vacancies. As you can see, the red line almost never dips below about 30%. Now it's gone up to 40%. So the problem is worsened. This is actually from an article I wrote in 2015 end, early 2016. This was published in Live Mint. This relates to data towards the end of 2015 approximately, and you'll see that there's a systemic problem as well, even with the district courts. So between 2006 and 2014, when the last data was available, you almost always have at least 20% vacancies in the district court and in the high courts. Why is this? No, because after all, our appointment is fixed by the judiciary. They should be in a position to fill the number of judges. They know who should be fit into who should be appointed as judges or not, but clearly they're not able to do so. The second one is a sort of the second chart that you see, which is all these bars, is a sort of a bit of an explainer as to what is going on. In the context of the High Court, every single year a certain number of judges are being appointed, but a certain number of judges are retiring. You'll find that there have been several years. If you see the 2007, 9, 10, and 12, more judges retired than were appointed. Which means in an approximately 10-year period, roughly half the number of years, more judges retired than were appointed, right? So, if this pattern follows, and even if this was before the number of judges in the high courts were increased, if this pattern follows, if you just simply extrapolate it, it will take 33 years before we can say that we have full capacity in our high courts, all right? Keep in mind, I did not expect that it would actually get worse. It's gotten worse. So you can say that the time frame has gotten longer. You can see that it has actually become worse. And the consequence of that, and if the third chart is what is relevant here, the number of cases pending per judge. The numbers are not very clear, so I'll just read them out. In the Supreme Court, it's about 2,600. The district courts is 1,700. But in the high courts, there's an average of 7,000 cases pending per judge. Now, this number is only likely to have increased in the time that I made this chart and at the present day. The capacity problems have only increased. Now, let's go to a further level. Why is it? Why is it that this seems to be a systemic problem? This is not just the fact that the present government has picked up a fight with the judiciary and stalling appointments. That is true, but that's not the full explanation. The explanation also lies in the fact that the collegium is an ad hoc body. The collegium's composition keeps changing year on year. The collegium's judges are not those who are supported in any real way by the institution in making these appointments. There is no secretariat which keeps track of all the judges. It's impossible for 5 judges in the Supreme Court to keep track of the hundreds of High Court judges, let alone the thousands of advocates at the High Court level who are being considered for appointment. They will only go by what the High Court says. They will only go by what the IB says. Now, in the midst of this, you have other problems. Appointing judges is only like the third or fourth most important function of judges. Obviously, the most important function is deciding cases. The second most important function is actually running the court, right? You have to do all the mundane tasks of signing your orders, dictating your judgments, of ensuring that people come on time, you're keeping track of who's stenographer, where the stenographer, and all of that. Running that court is the second big part of their function. Appointment of judges is probably only the third most important function. And they have to somehow find time after they do the first two to appoint these judges. So there is an institution, there's a lack of information that they have to process who is a good judge and who isn't. And they also lack the kind of time needed to think seriously about appointments. So as a result, what you have is that the backlog keeps increasing. You keep having difficulties filling up the posts because the collegium meets only rarely. There's one further factor which complicates this, haven't gone to yet. The collegium only meets rarely. When they meet, they approve a bulk list of people if that bulk list has come in before. There is one other factor complicating it. And that factor is that chief justices have had a shorter and shorter tenure. Now, if you compare the tenure of chief justices from the 50s, 60s, 70s, 80s, and 90s, you will find that the average length of time a judge spends as Chief Justice of India has steadily decreased. It used to be close to 2 years, now it's less than 1 year. What that means is that you have literally no time to shape the institution that you work in. As a Chief Justice of India, you're not just another judge who's passing orders, who's giving judgments, who's doing the routine things. You also have a leadership function. That leadership function would be stuff like, okay, let the collegium meet on this day. How do I resolve conflict in the collegium? How should I ensure that a certain number of appointments are made? What are my targets? What are my goals? Right? If you thought of any company which changed CEOs as quickly as the Supreme Court of India changes Chief Justice, you'd think this company is headed for disaster. Right? But that's what is happening in our Supreme Court. Chief Justice of India are spending too little time. The present incumbent will retire in October, having spent only little more than a year. That's actually above average. So, this is a serious problem. You have an institutional problem where the institution of the judiciary is unable to make appointments on time. But that only explains one half of the big problem. The second half of the big problem are our district judges, the subordinate judiciary. Now, in the context of the subordinate judiciary, those of you who are sort of tracking, say, Supreme Court cases will note that about a year, at least 2 or 3 appointments to the subordinate judiciary are challenged all the way up to the Supreme Court. I was just discussing this with Prashant a little while ago. You will find the amusing prospect of the administrative side of a high court challenging the own high court's judicial decision in the Supreme Court. So it is technically the High Court of Hyderabad challenging the High Court of Hyderabad's judgment. And that's because the process of appointment is usually inevitably challenged by the losing candidates, those who didn't make it. It goes up to the High Court, completely different considerations are applied, appointments are set aside. You will find on average, and this is a Vidhi report which just came out shortly, about a few months ago, that there are real issues in making appointments on time. A lot of high courts are the ones who are in charge of making appointments of district and magistrate level judges, subordinate judiciary, and they are not able to make the appointments on time. Now, you could say, given that the scope of the problem is much larger, the fact is that at least there are 24 different high courts doing this function is at least it's a little bit better. So, which is why you'll find that the appointment system has been relatively, the number of vacancies has been relatively better than the High Court is stuck at about 20%. Vacancies have been stuck at 20%. But what it tells you is that the existing system is not able to keep up. It's not able to keep up with the demands of the number of judges. And it will make absolutely no sense. I mean, there was this ridiculous figure which was floated about 3 years ago by the then Chief Justice of India, T.S. Thakur, that we need some 70,000 judges. That's an insane number. You're not able to appoint 20,000 judges. Where are you going to appoint 70,000 judges from? And it's not that you're not going to find enough lawyers to appoint judges. It's just that the process is so broken. The process is so incapable of ensuring this particular outcome that it doesn't really matter what goals you set or how much you feed into it. It is going to fail all the time. So, this is broadly what I want to talk about. This is the capacity issue, right? This is the capacity issue in our judiciary that institutionally is no longer able to replenish itself. It's no longer able to fill the vacancies with quality judges and quality judges from the lower down and judges and lawyers to fill the post of the judges. The next point that I want to come to is the constitutionality of it. Now, when I say the constitutional role of the judiciary, don't think about Articles 131 to 140, right? Although these are articles of the Constitution which vest a certain jurisdiction in the Supreme Court, the fact is there is a constitutional role that the court has as a constitutional role. So yes, even though SLP is provided for under Article 136 of the Constitution, that is not what I mean by the constitutional role of the court. The constitutional role of the court is its role in interpreting the Constitution, in adjudicating constitutional disputes. So we are talking about issues relating to the constitutionality of laws. We are talking about issues relating to interstate disputes between states and center. We are talking about issues relating to fundamental rights, competence, whatever that you will study in Constitution 1 and 2. But what has happened over the years is that the Supreme Court performs this function less and less and less. And this chart sort of illustrates that. Now you can see about 5 colors on this chart, right? This is from, I'll just explain that. So this is every case filed in the Supreme Court in the year 2014, right? The total number is about 39,000. I'm not sure if you can see that. Yeah, the total number is not here, but anyway, the total number of cases this is looking at is the 39,000 cases which were filed in the Supreme Court in the year 2014, okay? This, I mean, we have not segregated separate petitions. Supposing if somebody had 5 different pieces of property and they filed 5 petitions on the same question of law, we have counted that as one case because the court was going to hear all those 5 cases together. So this is the total number of cases filed in the Supreme Court. This is a breakup of the total cases filed in the Supreme Court in the year 2014. You will find that SLP constitutes about 80% of cases. All right, SLP constitutes about 80% of cases. Appeals constitute about 4% of cases. Transfer about 5%. Review about 7%. And here, this 3.24%, those are writs. Those are your writs under Article 32, right? So, the Supreme Court, the number of cases in a year where it is asked to exercise its constitutional jurisdiction under Article 32 is only about 3.24. In this 3.24% are all your PILs, are all your cases challenging laws and various actions of the government under Article 32. Even though you may find that if you pick up the newspapers, you'll think this is the other way around. You'll think 80% of the Supreme Court's jurisdiction is actually PILs and writ petitions, and only 3% is SLPs. In reality, this is the situation. So, you have a situation where the court is dealing with writ petitions and there's only a small percentage of its cases. And what is happening is that the court is telling people, go to the high courts, right? Even though, and if you have done Consti 1 or 2, as the case may be, you know that Article 32 is a fundamental right. The right to approach the Supreme Court itself is a fundamental right. The Supreme Court is telling litigants, go to the High Court first before you come to us. That's how a lot of writ petitions are getting disposed. I haven't put that chart here, but I can tell you the figure. Of these 3.24% cases, more than 60% are disposed in limine. More than 60% of the small number of writ petitions are actually disposed of in limine. Meaning on the very first day, in the very first hearing, court says there's nothing in this, or saying go back to the High Court. So which means, what is the court really doing? What is the court really functioning as? It's bring me to the next chart. Now, this is from a very interesting article written by Nicholas Robinson and a few others, published in 2011, Economic and Political Weekly. You should be able to find it online. This is a chart which sort of this shows you how steadily over the years the Supreme Court's constitution benches forms less and less of its function. That means, so if you look at, let me just go through it a little bit detail. Now, if you look at if you look at the 1950s, for instance, the first 2 entries, you will find that constitution benches, as in anything more than 5 judges, was about 13 to 14% of the court's docket, right? Questions concerning, obviously, the interpretation of the Constitution. It was the first decade of constitutionalism, fair enough. It was about 13 to 14% of the court's docket. But what happens every subsequent period of 5 years and every decade, as you can see, it comes down to the point that actually constitution bench cases form a negligible part of the court's docket. If you come down to the last decade for which they have data, 2005 to 2009, it is 0.12%. And I'm absolutely 100% sure that that number has only shrunk in the last 8 years. It may have improved in the last 2 or 3 years because of the fact that we've had a few more constitution benches. But if you look at constitution bench judgments, which have been delivered by the Supreme Court, as a percentage of its overall workload, it is becoming a vanishingly small number. This means that the court is spending more and more of its time handling routine appeals, handling routine issues, and not performing its constitutional function. Classic case, BCCI. I've lost count of the number of hearings that have taken place in that case. And the worst part is, all of it may be undone simply because the court does not have time to list and hear the case, right? Sahara. I've lost count of the number of hearings that have taken place in that case. No constitutional issue, purely whether this person is a crook. Court is doing what is essentially the government's job. Now, it may be a good thing. Good things happen out of that. But we have to understand that this court is no longer functioning as a constitutional court. It is performing some part of its constitutional function, but that seems to be almost an afterthought. Two most recent examples. The Aadhaar case took about 2.5 years before it went from reference to disposal. Now, we're not talking about, say, one particular law that is affecting about 1,000 people or 2,000 people somewhere there. I mean, even those cases should be heard quickly. But we are talking about an issue which has permeated all aspects of governance and is something that is crying out for a resolution. It took 2 years for the Supreme Court to even constitute the Constitution bench. And it's still going on. If you ask me, the present manner in which the Supreme Court is hearing that case is nothing short of a disgrace. You are having the Supreme Court list such an important case on 2 days a week, and not even every single hour of those 2 days of the week. It is being heard 2 hours before lunch, 2 hours after lunch, out of a possible 6 hours. So you have one of the most important cases in the last decade or so being heard for about 20% of the courts, of that bench, not even the court, of that bench's actual time during a week. So, which begs the question, what is the Supreme Court actually doing? Is it just behaving like just another court of appeals? Is it performing its constitutional function anymore? And what are the implications? Can we expect the court to adjudicate on these important questions of the interpretation of the Constitution if it is devoting such little time to the way in which these questions are being addressed? Now, this has another implication, and which is far more worrisome. It is that two-judge benches are taking such important calls on the interpretation of the Constitution. One, because it affects the way in which that issue is addressed. There's a reason why the Constitution has, you should have at least 5 judges on a bench concerning an important constitutional question. You want different perspectives, you want different views. You want judges to debate the issue and talk about it, maybe write dissents, write concurring views, when they are addressing an issue which is necessarily going to have multiple points of view. But if you have a two-judge bench, the dynamics change completely. Pretty much what the senior judge says goes. It's a very rare situation that you have a dissent by the junior judge saying that I disagree with this. So you have the extraordinarily awful judgment of the Supreme Court in Nas Foundation. This was argued before a two-judge bench, and pretty much the prejudices of one judge gets reflected there, or I would say even both judges. Now, I won't say the outcome may have differed if you had 5 judges. The outcome may have even been the same. But there is a potential for discussion and debate among the judges, right? It's not as if the Constitution says 5 heads are better than 1, or 2, or 3, or 4, or that 7 are better than 5. It's because you expect that there is a certain level of discussion and debate within the bench when they are adjudicating such important issues. You don't leave it to the wisdom of one or even just 2 people. But what we are left with is such important issues getting decided by 2-judge benches, right? And now, of course, a constitution bench will revisit it. But you're talking about 4 wasted years. You're talking about 5 wasted years, I think, to be honest, given the number of times this case has gone up and down. So, to that extent, I think this is a serious problem which afflicts the court's constitutional function. I'm not giving specific citations at the moment because a lot of what I've said has been said by a lot of other people. So, I will probably circulate a list of readings if I'll post the talk if you'd like. But one book I'll highlight right now and which you all must read is Anuj Bhuwania's Courting the People, right? Anuj Bhuwania's Courting the People, it is, I think, a book that must be read by every law student and lawyer, if you ask. It takes a hammer to your understanding of the PILs and you'll never see them the same way again. It sort of makes the claim, and I think it's a very important claim to make, that PILs, far from actually helping the people it's supposed to affect, people it's supposed to, has harmed the judiciary in a way. All right? Now, I don't want to spend too much time discussing because this is an invitation to Lavish to please call Anuj Bhuwan and ask him to speak about his book. Oh, already did? Oh, okay. Shame. Should ask him to come again. Oh, okay. All right. So, if you've already attended it, that's great. But you should also, you should check out that book. It's a fascinating book on what the process of PILs, what entailed into the court taking up PILs so much, has done to the judiciary itself, right? We can forget about whether PILs enabled the outcomes they were trying to, but what it has done to the judiciary itself is something that has affected the way in which the judiciary functions. Which sort of brings me to the final theme of my talk, and I'll spend a little bit more time on this part. Now, when we are talking about the judiciary, and when you're talking about the credibility of the judiciary, there are two other C's that I want to bring into the topic. One is corruption and criminality. In just the last decade, right, since I finished Nalsar, we've had 2 High Court judges face impeachment proceedings and resign before it was complete. We still have 1 High Court judge facing, 2 High Court judges actually facing criminal trial for corruption. 1 High Court judge has been stripped of judicial work for misconduct and potential corruption. There are 2 judges currently facing disciplinary hearings within the judiciary for conflict of interest. And I haven't even mentioned Justice Reddy of the Hyderabad High Court, who had an impeachment motion start and then stop before it went any further because of lack of signatures. This was on the basis that he had directed casteist abuse as another judge of the subordinate judiciary. We have also had 2 Supreme Court judges who have faced allegations of sexual harassment post their retirement, but for incidents which took place when they were judges of the Supreme Court. To these 2 C's, I'll add one more C, which is contempt of court. Just in the last 18 months or so, we have seen 1 former Supreme Court judge of India face contempt proceedings, but the court closed it. And another judge of the Madras High Court and the Calcutta High Court face contempt proceedings, be sentenced to prison for 6 months for criminal contempt, and of course create a great drama for all of us to follow on television. What all of this has done, and this is what a lot of people don't necessarily say it out loud, is that this has seriously dented the credibility of the judiciary. See, judges are not infallible, right? They come from the same society as everyone, as all the rest of us. You could say that the judiciary is not necessarily representative, fair enough, but they don't come from Mars. What most humans understand as incentives and disincentives, they understand as well. So they are going to make errors in different ways. But my point is the judiciary as an institution has the obligation to ensure that these errors of judgments, if we want to put everything in one big basket, that these errors of judgments are rectified. Now, impeachment is the ultimate. Right? That's a purely political process. It's understood that it's a political process where you're saying it's the ultimate punishment for a judge. But that doesn't mean the judiciary can wipe its hands off on problems internally. Now, to take that term corruption again, right? Corruption, if you can ask me, can happen in 2 ways. Which brings me to my next chart. So this is data which was presented in Vidhi's briefing book, Law by the Numbers, came out 2016. These are actually 3 charts. I'll go through them. One kind of corruption is the more obvious definition of corruption that we all know, which is for monetary or other gains that you provide some benefit to a person which they're not entitled to. But the other kind of corruption is something that is less obvious, right? It is less obviously quid pro quo and it's more subtle. And that is the corruption that comes from the judiciary meeting the executive's whims when it comes to cases in the hope for post-retirement jobs. So what you have here are 3 charts. I shall try. Is it possible to expand? Okay, I thought it would be much clearer on the big screen. Okay, all right. So here's, okay, I'll is it possible to zoom? Yeah, okay. So while they're sort of zooming that in and out, this is sort of data which my colleague Orgo Sengupta, also the founder of Vidhi, sort of compiled and put together for this particular entry. This lists out where judges have found themselves, Supreme Court judges have found themselves post their retirement in the last, actually since independence. So, if you can just, is that clear? Sorry? Okay. Anyway, I'll read it out. I'll read it out for your benefit. So, you have ad hoc tribunals, you have other permanent bodies, you have other posts like governor or lokayukta, you have ad hoc commissions and committees, and the maximum number is permanent tribunals and adjudicatory bodies. So this is a total of about 50 odd judges. This is what they've been appointed to after their Supreme Court judges. This is what they've been appointed to after their retirement. The second chart that you see, if you can just scroll to the left, who is appointed there? All right. And the top one, the fewest, is the president directly. This next is president and consultation with CJI. The third is state government, and the fourth is state government and legislative assembly. These are the state level lokayukta bodies. The fifth is central government and parliamentary approval. But coming down to the last and the biggest category is the central government. Right? That's about 35 odd judges. They've been appointed solely by the central government. The last chart is when did this appointment take place, right? The last is before retirement. The second is 0 to 1 year, 1 to 3, 3 to 5, and over 5 years, right? Now you can see the biggest chunk is between 0 to 1 year immediately after their retirement, right? So this is the key moment, clearly, when a lot of judges seem to get appointed to other posts. Now, you could say this is just correlation, right? Doesn't really seem to say exactly how much. You could use this data to cause those doubts. But I'd suggest that all of you read this wonderful piece that has been written by Madhav Ane, Shubhankar Dam, and Giovanni Ko. It's a little heavy on the economics jargon, but it's fine. You can take your time to go through it. The key takeaway from that is that they have looked at judgments of judges 1 year and 2 years before their retirement, and in significant cases. They're not looking at your run-of-the-mill bail cases, they're not looking at your run-of-the-mill criminal appeals or anything. They're looking at significant cases, and they have a specific definition of significant cases also, which you can see in their paper. And they found that controlling for everything else, when there's a possibility that the government will continue after their term is over, they start to favor the union government, right? And it's very clear that there's no other factor. They run a series of tests and checks to make sure that they're not showing up some other factor. What they find is that there is a very clear bias towards the union government as they get closer to retirement, right? So judges seem to be, and that sort of confirms the patterns that we see here. Judges seem to be favoring the government closer to their retirement date in the hope of a post-retirement post. Now, this is obviously a huge concern for the judiciary, right? See, independence is not just something that we'd like in a judiciary. If it is not independent, it's literally not a judiciary. If judgments are going to be passed, it's pretty much another wing of the government, right? It's another wing of the government, and even there's an obligation, if you have done your administrative law, there's an obligation on quasi-judicial authorities, even within the government, to exercise their own judgment and their own independence in these matters. Now, if the apex judiciary, which has such detailed provisions to protect its independence, is not able to do so, then we have some serious problems on our hand. All right? The credibility, and coming to so all of this discussion, and I think I have about 8 to 10 minutes more, I'll try to wrap it up. All of this sort of brings us to the point of credibility. All right? Now, credibility is the hardest thing to measure, right? It's never something that, there's a meter or there is a set of stats and numbers that you can easily pull out to say this is what credibility is. You may carry out empirical surveys to find out how many people trust the judiciary over the executive, over any other body, but that's subjective. You are comparing it with reference to some other bodies. But in and of itself, do people trust the judiciary? And this is where the last chart comes in, and possibly the most troubling one. All right, this is actually two, so I'll just put this back in slideshow. This is actually two charts, and one which I think really should be causing a lot of people to lose sleep, but clearly it's not. This is not some great data that I have unearthed after years and years of struggle. It's actually data that has been put out by the Supreme Court itself. You'd think that anybody who reads the court news publications will come across, but clearly nobody but me reads the court news publications. But these are the two charts which compare the trend in civil cases filed in the high courts and the district courts between 2005 and 16. Okay, this is an 11-year period we're talking about. And you will see, and you can see clearly in the high courts are in blue and district courts are in red. The trend line is falling down, right? It increased a little bit, but stagnated and is now on a definite downward curve. Likewise for the district courts. We have data only up to the end of 2016, and even to the end of 2016, you find that there are actually fewer cases in the district court and in the high court than they were in 2005. In a period of time when the opposite has happened for criminal cases. We can just move to the side. Yeah, sorry. On the other hand, criminal cases filed in the high courts and district courts have gone up. Right? Now this tells us a few things. The most obvious thing is that where people have a choice, they are not going to the courts. In criminal courts, there's no choice. The police, you end up going to the courts. Somebody files a criminal case against you, or the police file an FIR against you, you go to the court. Whether the prosecution continues or not, it happens in the courts itself. There's no choice in that matter. But when it comes to civil cases, you have a choice. You have a choice of A, letting it go, obviously. You have a choice B, of arriving at a negotiated settlement where you take some hit and you're okay with it. C, you find your local dada or your goon or your police officer and get them to resolve the dispute. D, you find some alternate dispute resolution mechanism which works, which is not always the case. E, you go to the courts. Clearly, people are saying, we'd rather go for any one of 1 to 4 than the courts. Now, there's another interesting article that I don't know if you have read it, but this is a piece called it's Litigation as a Measure of Well-Being, right? This looks at data just prior to what I have examined here, or a little in the first few years of the examination. This is by scholars in U Chicago. This is Professor Sheetal Kalantri, Theodore Eisenberg, and yeah. At Cornell, and Nick Robinson. They look at the rate of filing of civil cases, and they find that within India, it fits the global pattern. Better off states have more civil cases filed per capita than less well-off states. But across India, there's a pattern which is not being found worldwide. In most countries around the world, when population increases and when there is economic growth, you will find an increase in the number of civil cases. This is only logical. Economy expands, more transactions take place, more disputes arise, people have more problems or some damage occurs, number of cases should increase. But in India, you're finding that the cases increase very slowly or not at all, and as we have found, actually decrease, right? So what we are seeing and what this data is telling us is that people are actually voting with their feet. People are actually voting with their feet and not going to the courts at all. Strangely, Bollywood figured this out, I think, more than anybody else. And if you have seen the film Khosla Ka Ghosla, right, you will see there is one montage where they go from all the people A to E that I mentioned, looking for someone to help them get back their property from an encroacher, and they don't go to the court at all. Right? They find all the doors shut and they choose not to go to the court, even though it's the cheapest option for them. The lawyer sort of cynically tells them, you can go to the court, but 20 years later, you may still not get the property. You will be dead, but the case will be continuing. So that was maybe just one case, but it actually illustrates what seems to be going on. A second example, actually, again, from popular culture. If you have seen the film Jolly LLB, the first one, there's a great scene in the middle, which doesn't actually add to the story, but it's an auction of a police, the post of a station house officer. And there's a reason why that post is being auctioned, because it's in Sadar Bazaar. Sadar Bazaar is in a busy mercantile area of Delhi. That means if any time merchants have an issue with each other or with someone, they'll come to you for resolution. They'll come to the station house officer for resolution. They will not go to the court. They will come there, both will pay some amount, get it resolved, or pay him amount and get it resolved either way, but they'll go away because there's certainty. It is done. It is finished. Station house officer can enforce his writ in that particular area. I mean, these are just two examples, but this sort of makes us think how people are perceiving the courts, right? How people are actually thinking about it. How people are making their choices on the basis of what they see in the way in which the judiciary is functioning. And what this chart, especially this, should tell us is that the future is looking bleak. The future for the judiciary is looking bleak. And why should it matter? I mean, if people are resolving their disputes, for better or worse, why should we care, right? I mean, for you and me, we may care because we are lawyers, we need to make our living, and oops, if people are not coming to us. But why should we really worry about whether people are coming to the judiciary for resolution of disputes? Because there's no question of rule of law without a functioning judiciary, right? You need an institution which is capable of applying and enforcing the laws if you really want to have a rule of law. If you're going to replace all adjudication by pure discretion, right, where whoever's writ runs gets to decide what law is or what the rule is, then I'm not talking about a rule of law system anymore. It gets fundamentally broken down. And what you're seeing, therefore, is a fundamental breakdown of the way in which the judiciary is functioning and in the way in which people are approaching the judiciary and perhaps possibly in the rule of law in India. So this is sort of what I wanted to talk about, and this broadly brings me to the point, which is that credibility of the judiciary itself is under threat, and this has grave implications for India, for not just people in courts, for lawyers, for litigants, but also for the way governance happens in India. One last coda before before I finish this talk. You're all still studying in Nalsar. And the one thing that I have realized in the last 10 years since I graduated in Nalsar is that there are no adults. Nobody's going to come and fix the problem. If you find that there is a problem, it's pretty much up to you to fix it. So, however you want to do it, this is the task that is before you. Thank you.